International law is the subject for which today I'm going to tackle, and I want to relate this to natural resources management at the international level. Um, we must agree that international law is basically international cooperation, and if that cooperation fails, then there is a disagreement definitely. So this calls for contractual obligations that there are parties, consenting parties, parties whose interest has met their minds, and parties who definitely have to have the capacity to enter into a contract. And at international law, it is not citizens that enter into that international obligations. It is states, matters between states, matters interstates, and matters among states. So that's why at international level we talk about things like conventions, protocols, agreements, pacts, because they are parties that have a common understanding and then think they can now work together. And this speaks to what we call the coalition of the willing. Because if in the event sovereignty of the other party is not respected, then you'll hear the other party grumbling or disagreeing with with how matters are being dealt with. And you have heard also people talk about the big sums, because that would mean that there are other states that think their rights are being trampled on and they don't have any other recourse to rather than walk out of the agreement. International law evolves from a Latin phrasing called pacta sunt servanda. It basically means that um, if you have entered into a contract, you are duty bound. You are required, in other words, to comply with it. And that's what takes me to the failure of international law in regards to compliance. And it is not necessarily African states or the low developed countries that fail to comply. Even international or developed countries find themselves failing to comply. Now, natural resources uh, include or are not limited to those resources that can deplete, meaning they are there for a limited period, and that wise use of those resources for natural resources purposes, management, utilization is key. That we utilize these resources sparingly for the benefit of the future generations. Or we reserve these resources for our national treasure. Or we reserve these particular resources for the better good. Such resources that deplete are, I will give an example: minerals, um, oil, petroleum. That one will definitely at some point deplete. And that is why no country can be allowed to enter into the OPEC, which is oil producing countries, unless its petroleum deposits are commercially worth, meaning that those resources are there for uh, a given time and that those resources are there in plenty. So, but those resources, specifically the oil, I will give the example of Uganda, because oil is being tapped from the Albertine region. And this Albertine region is full of plenty of biodiversity, that is, fauna and flora. The plants the plants, vegetation for that matter, and the animals. And this coexistence is definitely going to be disrupted with the oil production. But that calls for government to build capacity, build a legal framework, and also build an institutional framework that is going to harness this oil without failing the environmental conservation principle, called sustainable development. Sustainable development, in my personal opinion, would mean that a total conservation is not good because it does not, in a way or the other, be seen to alleviate poverty. And yet, a total development will definitely fail creating an ecosystem for which specifically human life can exist. So that is why the Brundtland Commission in this coined sustainable development, which means we balance the equation. In the Ugandan context, we call it balancing the boat, that you balance conservation and development. And this coexistence will definitely bring the desired good. And that desired good is poverty alleviation, as people are also breathing lungs. Um, Going back to international law. In this case, Uganda, as it explores its oil, as it harvests its oil, it has international obligations to ensure that the source of the Nile is not polluted through oil spills. And in the event these oil spills have any other violate international required obligations, then this will definitely affect the desired the desired environmental conservation, because the source of the Nile is a resource that Uganda holds in trust for all the other countries that are in the oil basin commission, or if you please call them the oil basin countries. I will name a few. There's Egypt, there's Sudan, South Sudan, there's Kenya, there's Congo, there's Burundi, Rwanda, and there's Tanganyika, Tanzania. So all these countries hold in trust, and definitely Uganda, as it explores for its oil, because it has the source of the Nile, it definitely has a duty of care to all those countries. We must agree that Uganda is a member of the treaty that establishes the East African Community, and in the East African Community are, because this started as a tripartite agreement. That means that Kenya, Tanzania, and Uganda, the trio, the three partner states, signed to the treaty which established or revamped or rejuvenated the once failed to agree East African Community. And then countries that ratified the already existing tripartite agreement are Rwanda, followed by Burundi, and then the latest is South Sudan. So that is under you, the East African Community is looking at a superstructure which at the apex would be the political federation. And as we speak, the East African Community is still trying to understand the Common Markets Protocol. Now, at the in African continental level, we have the African Union. The African Union is a creature of the Banjul Charter, which also is called the Human African Charter on, the African Charter on Human and People's Rights. And this creates a semblance of a political or governmental structure, because it has the legislature, the African Legislative Assembly. It also has the judiciary, the African Court of Justice, and it also has what you call the executive or the political wing, which sits as the African General Assembly. The same is a replete of the United Nations, which is a creature of the United Nations Charter, and it has the African, rather, it has the United Nations General Assembly as its most powerful organ, but it also has other organs like the Security Council. Um, Also, it has the United Nations Environment Program. which is charged with the responsibility of environmental protection. But in this case, I want to bring in uh, at international law, there is what we call the soft law and the hard law. And the hard law is that which would require, even if countries are not a party to a certain international understanding, they will definitely be required to comply. One of those examples is the Rome Statute. And this, of course, has been greatly uh, been contentious because the Rome Statute is the one that creates the International Criminal Court. And the International Criminal Court, of course, is one would call it an evolution from the International Court of Justice. Now, the International Court, Criminal Court for that matter, is I will pick out a few interests that it has. It is interested in war crimes and crimes against humanity. So, if anybody has committed a crime that tantamounts or has ingredients or features that will draw international attention, then such a person falls into the interests or the jurisdiction of the International Criminal Court. And cases, of course, the biggest number of cases are reported in Africa, and but there were the internationalized courts, which one of them was the International Criminal Court for the former Yugoslavia. And also in Arusha was sitting the International Criminal Court, which was interested in Rwanda crimes against genocide. So uh, genocide is one of those crimes that the International Criminal Court of Justice will be interested in, and most of the times the International Criminal Court, rather the International Criminal Court, will uh, look into matters that have not been already dealt with, or there is no willingness at the national level, and then it will have interest. The International Court, of course, is housed in The Hague, and of course, the International Criminal Court would also be interested in crimes against cultural sites, religious institutions, and those, of course, most of the times they are a national heritage, and the national heritage, definitely, the international tourism has an interest, and of course requires the countries or its citizens to protect them, not only for their own citizens who are existing at the moment, but even for the neighbors and the international world. For today, I want to end here, and I am pleased that you have given me this good audience. I am happy, and next time we will have to deal with some of the international law terminologies. I want to sign off and wish you a good uh, visit whenever you come to the Pearl of Africa. And please don't forget that whenever you're coming to the Pearl of Africa, please fly the crane to the Pearl of Africa. Thank you for now.